You suffered significant harm and injury at the hands of a careless doctor. And now you believe that your injuries are worth $3 million, $5 million, maybe even $10 million. The defense turns around and says, you know what? We don't agree with you. We think your injuries are only worth maybe $250,000 and maybe on a great day, $500,000. You and your attorney say, sorry, we disagree. What do you do in that instance? You want to know the answer? Come join me for a walk through Red Rock Canyon here in Las Vegas as I share the scenery and share some useful information that will help you understand how these types of malpractice cases work in the state of New York. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, I'm hiking today here with my family in Red Rock Canyon, and I had a few minutes to share this great information with you. So now, you believe that your doctor was careless in causing you significant harm and injury. A medical expert who has reviewed all of your records confirms that you do in fact have a valid case. Your case goes throughout the entire litigation process for an entire 2 years. And now you've been given a trial date. As your case gets closer to trial, the defense says, listen, we'd like to try and negotiate. We think this case can be settled. So now they begin negotiating, and they tell your attorney, listen, we think your case has a value of $250,000. Your attorney says that's ridiculous. This case has a value of at least $3 to $5 million. Your offer is outrageous. Come back with more money and then we might be able to talk. Okay, so they come back a few days later and say, fine. Our line in the sand, the maximum amount that we are willing to settle for is $500,000. And your attorney says, thank you for that additional amount, that additional offer. However, that's nowhere near what we believe that these injuries are worth. So you know what happens? Each side says, fine, let a jury put a number on it. Meaning, we'll go to trial, and we will now let 6 members of the community, people whom we don't know and you don't know, they will evaluate my client's injuries. They will go ahead and determine whether or not these injuries really are worth what we claim or what you claim, or something in between. How do we show the jury? And how do we get them to understand that your injuries really are worth what we believe they are worth? And it all starts with bringing in medical experts and your treating physicians and your own testimony. Your own testimony to describe to the jury exactly what your injuries are, what you are limited from doing, what problems you have today, what things you can no longer do or are limited from doing. And now we bring in various doctors who have treated you, who have examined and looked at and reviewed your medical records, as well as physically examined you. So now they can go ahead and start explaining to the jury all the details of the problems you experience now, whether or not you're going to need additional medical care and treatment in the future, including surgery, what disabilities or injuries you're going to have. And there's my family hiking with me. Wave, guys. And now the jury will begin to understand exactly what problems and limitations and disabilities you have as a result of what was done wrong. Only after listening to all that testimony can the jury begin to assess whether or not our version of your damages are accurate. Now, the defense will likely bring in their own medical experts to dispute every single thing that we have said. They are going to do everything possible to try and minimize and limit the value of your injuries. They're going to try and dispute the extent of your limitations. And they're going to try and show the jury that the injuries that we're claiming, they're not really as bad as we claim them to be. That's their goal here, especially if they know that they're going to have a difficult time showing that they were not liable and not responsible for causing your injuries. So you see, in these malpractice cases, we have to get through 3 different hurdles. At the very beginning, when the jury ultimately is asked to evaluate your case, the jury has to answer the first question, which is whether the doctor you have sued is negligent, whether he was careless, whether he violated the basic standards of medical care. If they don't get past that question, meaning if they don't find the doctor is careless, guess what? They never get to evaluate how much money your injuries are worth. And your case ends right there and you get nothing. Now, if they determine that, yes, the doctor was in fact careless, he violated the basic standards of medical care, the next question that the jury will be asked to answer is whether that carelessness was a cause of your injury. Lawyers call that causation. There has to be that link, that connection, a bridge between the doctor's wrongdoing and your injury. If there's no connection, if there's no bridge or link between what the doctor did wrong and your injury or injuries, guess what? The jury stops right there, and now your case is over, and you get nothing. You get no money. The only time the jury will begin to consider how much your injuries are actually worth is if they determine that the doctor was in fact careless, and if that carelessness was a cause. It doesn't have to be the cause. It only has to be a cause of your injuries. Only at that point will they begin to evaluate the extent of your damages and your limitations and your restrictions. At that time, now the jury will have to evaluate how much your injuries are worth. Let's say you have lost earnings and you were earning a certain amount of money, and now you have been unable to work for a period of years up until the time of trial. That's called past lost earnings. The jury will have to evaluate, and then they will take into account whether or not you were able to work into the future and what type of work you were able to do and how much you were earning at the time of these injuries. Now, that can be very, very significant. And by the way, we call that part of the damages, at least one part, economic losses, where we can actually calculate how much money you have lost as a result of these injuries. Another aspect of damages are something called non-economic damages. And what's that? That's something a bit more vague and falls under the category of something like pain and suffering. How do you evaluate someone's pain? They have endured all of this pain. They've needed pain medication. They've needed narcotic pain medication. They've required various medical treatments for years. They needed additional surgeries to try and fix the problem. They live with unrelenting pain every day, which limits your activities. And now, according to your treating doctors, you will need additional ongoing surgeries and medical care into the future. So now, how does the jury put a value, a price tag, on these particular non-economic damages? Well, in that instance, the court and we meaning your attorney, are going to ask the jury to use their common sense, to try and determine, to try and base their decision on something concrete that they can envision in their minds about what they feel is appropriate. Now, I should tell you this, and this is really important. Some people think that it's like workers' compensation, where a fractured hand is worth X number of dollars, a fractured toe is worth a certain number, a brain injury is worth a different number, inability to use a body part is worth a different number, and they have a schedule now, or like a menu of what they can select from. That is not how it works in these jury trials, in these civil medical malpractice cases. Instead, the jury is asked to use their common sense, to use their past experiences to understand how disabling and restrictive these injuries are, and how your life has been turned upside down as a result of what this doctor did. Based upon their common knowledge of 6 members of the community coming together, we ask them to reason together, to come and have a discussion about what they determine, what they feel would be appropriate in this particular instance. You should know that every single case is different, and it would not be fair to compare injuries from what you went through to what someone else went through, because there are so many different variables. You might be 30 years old and suffer horrific injuries, whereas someone else might be 60 years old and suffer similar injuries, but have different effects. A younger person with similar injuries might be able to go to rehab and might be finished with their rehab earlier. They might not have as much pain. Why? Because they are more resilient. And as a result of that, their injuries have affected them differently. That's why when somebody says, well, I heard about and I read about someone else's injuries and they got X number of millions of dollars for these injuries. Well, guess what? That may be entirely true. However, your injuries may be totally different. They're like apples and oranges. Even though somebody may have suffered the same type of fracture, it has affected you and the other person differently in many different regards. So why do I share this quick information with you? I share it with you because it's critically important when deciding whether or not to go forward with a case to realize that there are many different ways to evaluate damages. When we look at the same set of facts, the same set of records as the defense, how is it possible that we evaluate it differently and come up with a different value of your injuries than the defense does? One reason may be posturing. The defense may simply want to try and limit the amount of money that they have to pay out, knowing full well that they may be responsible for your injuries. In that instance, The defense coming in with a lowball offer may simply be an attempt by them, a strategy, to try and limit how much money they actually have to pay out early on in the case. If now we get close to trial, they may realize, listen, they may have no choice, because if this goes to trial and the jury decides on a verdict, they may come back and give you substantially more money than what we are asking for to settle your case. So a lot of strategy and negotiation goes into how much to offer and what the true value of your injuries are. And it's oftentimes a chess game. You know, I realize you're watching this video because you want to see the gorgeous rock formations here in Red Rock Canyon. No, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.